proposed. Can I present the agenda, its remitted bills, continuous work? Honorable members.
Chair, we require a mover and a seconder for adoption of the agenda, Chair.
Yes, can you ask for the mover?
Mrs. Hermans, Chair.
Come again?
Mrs. Hermans and Mr. Mubuyane, Chair.
Honorable Hermans.
Good morning, Chair. I move for the adoption of the agenda as tabled. Thank you.
Thanks. Honorable Mbuyane.
Chair, thanks once again. Chair, I second the proposal for adoption of the agenda. Thanks.
We still have to check. Are there any objections?
Recording in progress.
No objections. Let's then actually proceed to invite advocate to actually speak to us on the remitted bills. Can we then invite our member advocate to take us through the remitted bills?
Thank you so much, Chairperson. Good morning to you and good morning to the members. Chair, may I just, before I start, just explain what we've done. A team from Parliament and a team from the department sat together. We looked at the proposed amendments that the committee approved last week. We looked at wording to give effect to those amendments. So we have a document that sets out proposed wording for all of those amendments. What I've done in order to give members a bit of a better, like a bird's eye view of each topic, is I've grouped them per topic. So for instance, the document starts with the amendments that affect persons with disability. And then from once all those amendments have been dealt with, the document goes on to discussing broadcasting. So what I just would like to know from the committee is, would the members like me to take them through the whole document, so discussing all of the amendments per topic, or would the members want me to pause after each topic? Okay, if you can just guide me on that, then I can start.
Honorable members.
Mrs. Hermans, Chair.
Honorable Hermans.
I think, Chair, it will be useful if we pause after each topic, because the bite might be too big for us. Because for some of us, it's the first time we're dealing with legislation. Thank you, Chair.
Let's hear, honorable members. Is there agreement that we proceed? There were options. Honorable members, can we proceed as supported by Hermans? Or do we have any seconder for Honorable Hermans to proceed?
In order
because,
to...
yes.
Mr. Mubuyane and Ms. Mutahung, Chair.
Honorable Mubuyane.
Chairperson, thanks. I think let me second the proposal made by the whip so that each and every item are able to engage and understand properly before we can move to another one. Thanks, Chair.
Okay. There was another seconder or mover.
Chair, we have...
Who was it?
Mr. Burns Namashi was, and Ms. Mutahung's hand was raised earlier.
Yeah. Okay, Honorable Mutahung.
Thanks, Chair. I wanted to second Honorable Hermans.
Okay. All right. I'm sure there's no objection. We can go in those kinds of cutting of areas, advocate. So the option agreed suggested is that one for you to proceed on. Can I hand over to you, advocate?
Thank you. Thank you very much, Chair. I'm then going to share my screen. And I promise I will try and keep this little green thingy around my document in sight so that I know that it moves or doesn't move. So Chair, I'm going to start with, like I said, the first topic deals with persons with disability. I'm going to see if I can make my screen a bit clear for you. There we go. Okay. These amendments, of course, all have to be advertised, or most of them have to be advertised. So the first amendment dealing with a person that affects persons with disability was to change the definition of accessible format copy. Now, accessible format copy is where you take an original work and it's converted into something that is in a format that is accessible to people with disabilities.
I might need your help tomorrow.
I think someone
Okay,
is...
Comrade, there's someone who's actually linking up with us, Secretariat.
You should think I've
All right.
made a mess.
Okay, proceed, Advocate. Sorry
Thank
for
you,
that.
thank you, Chair. So the proposal to amend here on accessible format copy was just to align it more with the wording of the treaty. It's the only change to the definition, in fact, is simply this wording here in blue, where our bill talks about and permit, we now will make it including to permit. So it broadens it slightly. Then there's also a proposal for a new definition, that of authorized entity. Now, an authorized entity in respect of persons with disability will be an entity that is allowed to make these accessible format copies. So the proposed wording is that it is an entity that is authorized or recognized by the government to provide education, instructional training, adaptive reading or information access to persons with a disability on a non-profit basis, or a government institution or non-profit organization that provides education, instructional training, adaptive reading or information access to persons with a disability as one of its primary activities or institutional obligations. Now, one of the questions that might come about when we look at the definition of authorized entity is, well, what does it mean to be authorized or recognized by the government? So in order to answer that question, we have a further amendment, and I will get to it. That amendment deals with empowering the minister to make regulations relating to processes and formalities in order to so authorize and recognize these entities. So this is the definition. And then how do these definitions play into 19D? Now, 19D is our disability exception. So authorized entity is now going to play a role throughout this section. So in subsection 1, we are proposing that the words as may be prescribed be removed, but that we rather than say including an authorized entity, because these two are actually now going to be the same. So any person as may be described will, of course, be an authorized entity. So now that we define authorized entity, we might as well use that word. Then the remainder of subsection 1 is staying the same. And in fact, this does not have to be advertised, this amendment here, because it doesn't change the content. Now, it says subsection 1 talks about this authorized entity or persons that serve persons with disabilities being able to make an accessible format copy, and it gives some conditions. Now, these conditions A, B, and C are not changing in content. The content remains the same. But there was a bit of a concern that that paragraph B was unclear. What paragraph B tried to say was that when you make this accessible format copy, you may not make more changes to the original work than is necessary for purposes of making it an accessible format copy. But it did so a bit in a roundabout way. So what we're proposing is that we change paragraph B, and this again doesn't have to be advertised because it doesn't change the content, but we change paragraph B to read as the treaty reads. So it will now read, one of the conditions in order to make this accessible format copy is that in converting the copyright work to an accessible format copy, the integrity of the original work must be respected, taking due consideration of the changes needed to make the work accessible in that alternative format and of the accessibility needs of the persons with disability. So in other words, it says exactly the same thing. You may make an accessible format copy, but the changes that you make to the original work may only be those changes that are necessary in order for the accessible format copy to be made and to work. Then the other thing that we are proposing a change to, and this is still in looking at authorized entity, making that part of the subsection, is to subsection 2. So it's also aligning with the treaties and so on. The wording is we are suggesting that subsection 2 be totally redrafted. The wording of subsection 2 at the moment ends on for personal use, and it doesn't indicate for whose personal use that may be. So there's a concern that that might be broader than the intention was. But in order to do that, we have to split the wording and change the wording a bit and chop subsection 2 up. It still doesn't change the content, it just words it a bit better so that we make it clear that the personal use that we're talking about is for a person with a disability. And if an authorized entity is making that copy, of course, it is not for the personal use of the authorized entity, but for the personal use by a person with a disability. So it's just to make it a little bit clearer that what we're trying to do here is still to comply with the treaty. We are not bringing in extra strange exceptions here that allows authorized entities to make personal copies for themselves. Then paragraph B does not change, so I will not go into that. Subsection 3, and this is the one that will have to be advertised. So first of what we are recommending here is to bring in this concept of authorized entity. So a person with a disability or a person that serves persons with disabilities, which includes an authorized entity, may, without the authorization of the copyright owner, export to or import from another country any legal copy of an accessible format copy of the work referred to in subsection 1. So in other words, this accessible format copy for persons with a disability and so on. Now the addition here is to bring it in line with the treaty. We make it clear that this exporting or importing is for distribution or to make it available to persons with a disability. That's the purpose of the importing and exporting. So just tightening the wording so that it accords with that of the treaty. And then paragraph B was something else that the treaty has in its definition. We can't put it in the definition because it's substantive. So we're bringing it down here into section 19D. And we recommend that we add this, that this person who is now exporting or importing, so the person contemplated in paragraph A, referring to subsection 3A, so this paragraph is what we're referring to, may only so export or import where that person knows or has reasonable grounds to believe that the accessible format copy will only be used to aid persons with a disability. Now, what this does is it just places a positive obligation on the person who imports or exports to say, if you're importing and exporting and you suspect that that accessible format copy is going to end up in some market that is not for persons with a disability, well, then you should not be importing or exporting. But if you don't have any other, there's now no suspicion, you have reasonable grounds to believe that, in fact, this will go for persons with a disability, then you may import and export. So again, just aligning that, making it very clear that we are trying to comply with what the treaty is allowing. And of course, this tightening is because this is quite a significant exception that is allowed. And this tightening is simply to say that, well, you can make use of this exception, but the purpose of the exception we must not lose sight of that. And the purpose is to aid persons with a disability. So that is the rationale for paragraph B being added. In subsection 4, paragraph A is not something that has to be advertised. What it is, it simply speaks to moral rights. So there was a concern that the bill used the wording, as far as it is practicable, you must name the source and name of the author. You must give that. But the comments were, practicable for me, it's not practicable for you, and it's not clear. And in fact, the Act has wording that we can rather use and align the bill with the Act. And that wording is, if the name and source of the author, source and name of the author appears on the work, then you must indicate it in your copy. So that is not, this is simply changing the wording to be aligned with the Act. It's not changing the content. But paragraph B, we will need to advertise. And this again speaks to the treaty wording and that whole concept of why do we have this exception. And the purpose is that this accessible format copy is exclusively for persons with a disability. You can't bring it in or import it or make it for other purposes. It is for persons with a disability. So that is just, so the exception here is subject to the moral obligation in A, and B, that the use is focused on persons with a disability. So we will make the document available, and I've just made a few notes in the footnotes, but I've spoken to all of these as I have presented. Then the last amendment that deals with persons with a disability is, you will recall that I've indicated, when we look at the definition of authorized entity, you might ask yourself, but who and how does this happen? How do we know what an authorized entity is? So in clause 33, which is amending section 39, which deals with regulations, the bill provides currently a subsection 2, but we need to insert a new subsection 2. So the bill will change so that this will be a new subsection 2, and the current subsection 2 will now become subsection 3. So subsection 1 of section 39 gives a discretion to the minister to make regulations. It says the minister may make regulations on the following topics. Now, those are empowering regulations. In other words, it is where the minister deems it necessary to add to what the Act is saying, the minister may make regulations. But this is something where the minister will have to make regulations. Otherwise, there will be no authorized entities. Without these regulations, we will not know what is an authorized entity. No one will be able to apply to be an authorized entity. So that is why we need to then put it as a new subsection. So subsection 2 will now read, the minister must make regulations providing for processes and formalities related to the authorization or recognition by the government of entities that provide education, instructional training, adaptive reading, or information access to persons with a disability on a non-profit basis. So you will recognize already paragraph A of the definition being repeated here. So it's just to make clear that this is now, the definition says the what is an authorized entity, and the regulations say, how do you become this authorized entity? And then subsection 3, just to make it as a consequential amendment, the subsection 3 deals with when the minister is making these regulations, it must be published for a period. So we just add that this new regulation that we're now providing for must also be added, published for public comment for a period of not less than 30 days. So members, I'm going to first just pause there, because that is now the amendments that relate to persons with a disability.
Chairperson, Mr. Mbuyani and Mr. Burns, Marsha raised their hands, Chair.
Chair?
Chair may have a challenge. I do not know what that would be.
No, please assist the chair so that you can continue.
Okay. I'll try to call the chair quickly.
He's off the platform.
May I propose in the interim while the chair is off the platform. That Mrs. Hermans, you maybe chair the process going forward, if that is okay with the committee. Until I see the chair is back again.
Yes, Andre.
Here we have Mr. Mbuyane and Mr. Benson Mamashe raising the hands, Chair.
Oh, okay, okay. Mbuyane, Honorable Mbuyane.
Oh, thanks very much, Chairperson. I just have one clarity-seeking question here in terms of the person with disability. The accessible format copyright, yes, we agree, and it must be advertised. And also we acknowledge the new definition in terms of the authorized entity. Mine was a subsection, the new subsection, which gives the more powers to the minister to can regulate. I'm not so sure whether we're not going back to what we were in terms of the copyright before, or will still be giving the minister more power to can regulate in terms of these specific clause that need to be changed. Thanks.
Okay, Benson Mamashe.
Thank you very much, Chair. No, mine is I guess is much more simpler. I understand that there are certain matters that would have to be advertised. I just wanted to get more clarity on this issue about advertising. In simple terms, what do you mean? I'm raising this, Chair, triggered by what Honorable Hermans said initially, that it might be that not everybody is familiar with the law-making processes, which means that some of the nomenclature or jargons that may be used, because Advocate van der Merwe is dealing with these processes almost on a daily basis, it may be simple and easy for her to just make those reflections without realizing that she might be leaving other people behind. You know, there's a pedagogical principle, Chair, that says you move from the known to the unknown. You don't move from the unknown to the known. You move from the known to the unknown, from the simple to the complex, from the concrete to the abstract. So that's the logic of movement. So I would be happy if she can actually give some clarity, because to simply assume that we all understand, it may leave some of us behind. Thank you very much.
Okay, maybe with your comment, Benson Mamashe, it's a point of just confirming that the process is quite good, because I think we are in a discussion where we know which are the areas we may try and understand better so that we can be able to actually implement. And I'm sure for the advocate as well, is that we actually will get the advocate to get to the level where it's much more simpler. But for now, I think there are areas where one is comfortable. But other areas, you can see that it's something that's quite new. But thanks very much, because the advocate has been actually picking up on the issues. Which were the other hands which was supposed to be responded to, so that we can go back again to the advocate?
Chair,
Advocate is just said that we have to pick it up slowly. Andre?
no
Is
further
accepted?
hands, Chair. There's no further hands, Chair.
Okay, let's continue, advocate, because I think there is actually feedback that we're doing quite well. And I think in the discussion, we should actually then proceed on the same basis. And we actually would ask for you to be a bit patient so that we can actually then be at the same line with you. Advocate, can we proceed?
Thank you, Chairperson. Yes, and my apologies. It is exactly as the member indicated. It does come easy because I have argued this argument many times. So it almost is something that, you can wake me up in the middle of the night and I can tell you what the case law is and so on. If I can maybe just start with the question on why are we advertising? And it's very difficult actually, because we are dealing here with a Section 79 process. It's the same, but not the same as a normal legislative process. So already we are asking members to kind of pull themselves out of their comfort zone and become involved in a different legislative process. So we are limited at what we can do. And there's even behind the scenes, we as support staff have to speak to each other and to confirm that we are still on the right track. So yeah, it might seem easy, some of the concepts, but it is in fact quite complex because we must make sure that we comply with process. So although we have to limit ourselves, when we deal with procedure, where there was a procedural concern from the president's reservations, your bill opens up a bit. So your restrictions that are very, very limited when you deal with substantive matters become a little bit less, the lines become a little bit blurred. Now, because the lines become blurred, we need to keep in mind other principles. And now we need to look outside of the Section 79 process. And when we look at the constitutional obligation of the National Assembly in Section 59 of the Constitution, it says that the Assembly and its committees must facilitate public involvement on all its processes, its legislative and other processes. So we've had lots of court cases considering what exactly that means. And we've got the Doctors for Lives, the Mercer case. All of these have indicated that it is very important for Parliament to engage the public. But now we have a further concept that comes in here. So it just becomes more and more and more complex because this bill has been advertised and advertised and advertised and advertised. And we've sought the input from the public on so many levels, on so many things. But we then have a few other court cases that gives us some guidance on when can you stop engaging the public. Because now these amendments come about from inputs from the public. So why do we have to go back to the public? And what the courts have indicated to us is if there is a material amendment, so if there is something that the public definitely have not seen before, then they must be given an opportunity to comment on that. So the one example that I can give is the case of the South African Veterinary Association, where in the medicines bill, it wasn't initially, although the act involves veterinary practices, the bill initially did not specifically expressly include that practice. And from public comments, it was then clear that was an oversight and veterinarians should be included. And that was then done. and the bill proceeded. And the South African Veterinary Association objected and said, but they should have been given an opportunity to comment because they were not aware that they were affected by this bill. And the court agreed with them. So anything where we see that this is not something that it's such a gray area. It is really something that you need to look at, you need to consider. And there might even be matters where the committee might say to us, you said we shouldn't advertise, but we think we should. That is very, very, very possible. I might be proposing things for advertisement that members might say, no, we think that they've already commented on this. So it is a gray area. I'm simply making recommendations, looking at what I think is so new and so material amendment to this bill that the public needs to be given an opportunity to further comment on it. So that is just where the advertisement comes from. And I mean, from the lengthy explanation, you can see that it is quite complex because we've got about 3 or 4 different elements of the legislative process all coming together here. So basically, the recommendation for further advertisement is to comply with Section 59 of the Constitution to make sure that the public has an opportunity to comment on anything that is such a significant change that they might not have had an opportunity before to comment on it. So even though it was about something that was in the bill, it might be so different now that the public might not have thought at the time. There will be one a little bit later on. There's actually a very good example where we are we're recommending removing a paragraph from a definition, and it flips the definition upside down. So because of that, other members of the public might have thought, oh, I like the definition as it is, I'm not going to comment. But because we are now flipping it over, they need to have an opportunity to comment on that. And then just in respect of this subsection 2, the regulations that are now on screen, yes, indeed. So we are in fact adding to what the Act is currently providing for. The Act only provides for discretionary regulations at the moment. So this is an additional empowering provision where the minister will, if this is accepted, if this is then passed by both houses and assented to, the minister will be able to make regulations that will stipulate how an entity can apply for authorization to become an authorized entity that can assist persons with a disability. Chair, I'm going to move. I don't see any hands from what I can see. So I'm going to move to the next topic if that is in order. Pause a bit.
Who can proceed? Thank
you so much. Thank you so much, Chair. The next one is not a difficult one, but it's also a difficult one. It deals with broadcast. Now, first off, there's 2 different concepts here at play. First off, in our Copyright Act, we have a definition for broadcast. It's very different from what appears on the screen. So what happened was that the definition of broadcast in the Performance Protection Act was actually amended, or was being amended by the Performance Protection Amendment Bill. And the definition that you have before you now in blue, you will see that it's repeated there in the PPAB stands for the Performance Protection Amendment Bill. So the argument from the public was that you can't have one definition in the Performance Protection Act and another in copyright. You need to also amend it in the Copyright Amendment Bill. So that is why this definition appears here. So this definition is simply to align the 2 acts. But this is the easy part. The more difficult part is that there was also a proposal to remove the words wire from the definition. Now, this is something where I think there's a bit of contention. It is optional for the committee to advertise it as without the words wire. We can see what the public comments. There might be comments from the public to not do it. But we are also going to advertise broadcast regardless of whether wire is included or not, because it's a new definition. So it's something new. We need to give the public an opportunity to actually comment on this. And I think it's an option for the committee, whether we advertise with wire or without wire. But we need to just indicate that there might still be broadcasts that are made by wire. And then, of course, the definition itself will be excluding it. Now, there's also another concept, communication to the public. So if we remove wire from broadcast, it will fall under communication to the public. But it becomes a very technical argument that has to be made. So it is not that people who will broadcast by wire will be excluded. They will fall under a different definition, but there might be an impact to that. So, Chair, those are the two definitions or the two aspects around broadcast. The one is an easy one. It is, do we want the two acts to read the same? And if yes, we need to amend it in the Copyright Amendment Bill as well. The second aspect is this matter of including or excluding wire. And like I say, because we have to advertise, it's a new definition in the Copyright Amendment Bill. We need to give the public that opportunity to comment on it. It will be out there. We will be getting comments on the wire or wireless, but it is an option for the committee to consider. Actually, I'm going to pause there again because that is all that is in respect of broadcast.
Honourable members, if ever we have any comments on that.
Mr. Burns, Namaste, Chair.
Honourable Namaste.
Thank you very much, Chairperson. I just want to check something from Advocate Van on broadcast, you have two different definitions about the same thing, and in this case, broadcast, in terms of the Performance Protection Act as well as the copyright. Now, because the definitions are different, it's just a legal principle, what I'm trying to check. Are you then saying that no act can be amended through insertions on another act? Is that the case? For instance, where you will then say, by the insertion of this clause simultaneously, it equally that tantamount or equally amends a particular provision or section of a particular legislation which is relevant to the subject, or as an established legal principle, when you amend an act, you've got to effect that amendment on the principal act. What is it exactly? Thank you very much.
Let's check if there are any further hands, members. If not, Advocate Burns Namashe's comment.
Thank you, Chairperson. This is again another interesting legislative process question. Yes, of course, we can amend one act when we are amending another act. We do that either by way of the General Laws Amendment Bill, wherein more than one act is being amended, or we can put it in a schedule. So we can, for instance, if only the Performance Protection was being amended in this case, we could amend the Copyright Act by way of a schedule to the Performance Protection Amendment Bill. But what we have here is that these two acts are administered by the same department. And in fact, these bills have a very long history where they were one bill at one stage. And then there was a proposal that it'd rather be separated, so that you have these two concepts dealt with separately. And it caused its own problems, that split. Other legislative procedural problems. But what we have here is, because we have the two acts that are administered by the same department, we are currently amending both. And the arrangement was that both need to serve before the same committee at the same time because of that interaction between the two. So the proposal here in respect of broadcast to be also amended in the Copyright Amendment by the Copyright Amendment Bill is simply to make sure that the two acts in the end will remain aligned. So yes, it's very possible, but in this case, luckily we've got the two bills before, so we can do the amendment like that now. And then I don't see any hands coming up, so I'm going to move to the next topic, which is personal copies.
Yes, proceed, Advocate. Unless maybe there's a follow-up question. No follow-up question. Secretariat, is there any other hand?
No, Chairperson, there's no follow-up question.
Okay. No, Advocate, let's proceed.
Thank you, Chairperson. So personal copies, and between the two teams, we had a lot of discussions on this matter. And I'll mention some of the things that came up as I go through it. So the first proposal is for a definition, and that definition is for the phrase lawfully acquired. Now, the reason for lawfully acquired is we are dealing here with a specific exception related to personal copies. So it's a copy, you're not making this copy for educational purposes, for research purposes, for library purposes, for persons with disability purposes. It is simply a personal copy that you are making. And the argument is that you cannot, I read a very good example yesterday. One person goes to a CD store and she buys the latest release of a CD. She goes back home, puts it into a computer, and she copies it to a hard drive because she's not going to listen to it while she's busy working. And we all agree that is fine. And it's allowed between the Act and the Bill, it is perfectly allowed. The next person also gets home with her latest acquired CD. The only difference is she shoplifted the CD. So now is this copy that she's making, can we say that it's the same? No, it's not the same. You cannot make a copy of something that you have not lawfully gained that access to. So that is why we are proposing to include in the exception the phrase that you have lawfully acquired that work. And then the definition that is being proposed is a copy that was purchased, obtained by way of a gift, acquired by means of a downloading resulting from a purchase or a gift. It does not include a copy that you have borrowed from someone, that you've rented from someone, that was broadcast or streamed to you, or a copy that you've obtained by means of a download that enables only temporary access to the copy. So I think with COVID, we've all had these things where you could see a show by this temporary download and so on. So this is what all this lawfully acquired deals with. The problem that we discussed at length was, do we have unintended consequences here? And it becomes such a quagmire of where do you go? How do you limit it? And we really struggled with it. And what we in the end are proposing is this. So in respect of the actual exception, we are proposing first off that the phrase lawfully acquired be included there. This does not have to be advertised, but it shows just where the definition will fit in. The other amendments here are just because we are the first one here for the lawful, using a lawful copy of at a different time or different device owned by that natural person. This is simply because of duplication. So I will still get to the duplication, but you will recognize it as well when we get there. So 12A had provision for these copies, and the proposal was that we don't do this duplication where 12A and 12B speaks to the same thing, because you might have different factors applying to the two. But if we delete it in 12A, then this wording here, using at a different time or a different device, the example that I've just given of the person who bought the CD, put it into the computer to listen on the computer, even if the person is away from home and the CD is still at home. So that is what this is providing for, a different time or a different device. So we're including that there simply to avoid losing that factor when we are getting rid of duplications, making it clear that it is something that is owned by that person. And this compatible with fair practice was just, there was also a request that we shouldn't be using to the extent justified by the purpose, we should rather use compatible with fair practice. So that was the proposal, to rather align the wording of the bill throughout with the Act and with the treaties. So that is what those two are about. The main thing here for the committee to consider is this lawfully acquired being added there. So the first big concern that we had was, okay, but how do we make it clear that this does not apply to libraries, to education, to research? So the proposal there is to change, it's currently subsection 12b2, but it will become 3, and you'll see later on because we're proposing a new subsection 2, to change it by making the first part that is currently there a paragraph A. So the first part will remain as it is. Permitted personal use will include the backup copy, format shifting, making it for storage, and so on. But then we add something to say that these factors associated with making a personal copy set out in subsection 1I do not apply to a copy made in terms of another exception provided for in this Act. So in other words, we make it very clear that these factors that we've got here, especially this lawfully acquired, is not something that you will look at when you look at libraries. There are other factors that we will look at when we look at whether a library is making a copy in terms of the Act. There are other factors that will be looked at when we look at education and whether for educational purposes that copy is made in a way that does not infringe copyright. But you're not going to combine those factors with I. So that was the first proposal that we've made. Then I've here, like I said, this document will be sent to the members, and I've made some additional notes. And these two authors, and I'm not sure how to pronounce the surname. I think it's Persnowski, something like that, and Schultz. And I apologize if I pronounce that incorrectly. Indicated that when we look at law, especially when it comes to personal copies, and because this is in fact a dilemma, and this is a 2012 article, and just to give you an idea, this issue of personal copies has been a dilemma in copyright for some time. And they were saying that what most countries would do is to allow courts to develop and to look at the specific circumstances of the case. And what they were saying is that they are concerned that if we become too prescriptive, and that might be in our definition, we might be too prescriptive in our definition, that we might tie the hands of the court, because they might say, I think that what you're doing is fair, but I can't, because the Act says I must look at these factors. And if I look at these factors, you are definitely infringing copyright. And these authors were also saying that if they ask copyright owners about certain personal uses, everyone would agree that certain personal copies that are made are in fact not infringing, unless it was for the Act saying so. Because if you ask these copyright owners, but where's this exception in the law? They cannot find it. So this is what the dilemma is with personal use. And that was the dilemma that we faced when we were drafting these documents, the proposed wording. So the one solution was this addition of paragraph B to exclude other exceptions. So it's now only those minimal personal use issues that might still be a problem. And what we want to recommend to members is the definition of lawfully acquired is a new definition. It will have to be advertised because the public has not seen it before, and they will need to get an opportunity to comment on it. And our recommendation would be, whether in this wording or other wording, as we will get inputs from members, that it be advertised, that we advertise the definition, but that we keep in the back of our minds that this is a personal copy dilemma. And it is something that when we get inputs from the public, we might decide not to define lawfully acquired and to leave it to the courts. So what will happen then is we will retain the word lawfully acquired in the exception, but we will not tell a court or the user or the copyright owner what exactly lawfully acquired means. In other words, you will be giving courts that leeway to look at the facts of the matter. But we might also get inputs that this definition is perfect and that it is exactly what is required in order to give that balance between the rights of copyright users and copyright owners and the rights of users to use their own personal property. So, Chair, I'm going to stop there again because that is the gist of the issue around personal copies and the proposed amendments.
And any comments, honorable members, on the copyrights copies, personal copies? If ever there's any comments, questions, honorable
Chair?
members? Yes.
No hands at the moment, Chair.
Okay. Advocate, we can proceed.
I hope I did not confuse people and that's why there's no questions, because I felt so confused about this personal copies. I went to and fro in my head about it, but I suppose, like I say, it is a dilemma. We know it is a dilemma. The next is, and I apologize for the abbreviation at the top there. It just stands for Technological Protection Measure. And the S is just to make it a plural. So I actually should make it a small S. Technological protection measures. Now, let me maybe quickly try and explain what we are dealing with here. A technological protection measure is, I don't know if anyone has ever perhaps bought a CD. My example, the woman who bought a CD, the latest release, she popped it into a computer and suddenly she realizes, but this doesn't want to play. And if she looks at it further, the computer pops up a message to say, you're not allowed to play this CD on a computer. And the reason for that would be a technological protection measure. All our vehicles with computers, there will be technological protection measures to prevent people from copying information in that computer. It becomes quite a competitive thing, especially on that. So what is it? And this is actually the definition I've tried to explain, but let me say how we will put it in wording in the bill. It means any process or any treatment or any mechanism or any technology or any device or any product, system or component. You can see it's very broad. It's a lot of things that are covered by this. That in the normal course of its operation is designed to prevent or restrict the infringement of copyright in a work. Now, initially, this definition had a paragraph B. And that paragraph B, apologies for looking away, I'm just trying to get my bill quickly. That paragraph B dealt with things that are not a technological protection measure. So we said, this is what it is, and then we said, this is what it's not. And what it is not is very much the same as what we've got here, but instead of this to prevent or restrict, it ended with to the extent it controls any access to a work for non-infringing purposes. Now, the argument was that we're getting caught up in a roundabout definition here. We're actually excluding technological protection measures that should be included, because if you apply your circumvention devices or services, then it's no longer an infringement. But then does that mean the technological protection measure that is being circumvented is no longer a technological protection measure? So very much a circular technical argument, but there might be some merit to it. There might also be unintended consequences. So although initially when I took the members through amendments to be made, to be advertised, I did not include the advertisement of technological protection measure, I would like to now recommend that we do include it. And one of the concerns is, and especially the big examples that we have comes from America, where there was a technological protection measure definition put into their bill, and it resulted in normal activities, people not being able to do those normal activities anymore. A farmer could not repair his tractor because he could not bypass, he could not circumvent the technological protection measure because of how it was now defined in the bill. So I'm just cautious about whether changing this definition might have that impact. So we've listened to the one side. We understand that the definition seems to be circular and it seems to be nullifying itself. So we understand that argument. But by changing it, are we having unintended consequences? And for that reason, I would recommend that the committee does in fact advertise this proposed change specifically of these two things that we've added, the design, the product, but also the deletion of paragraph B. And let's just see that there are no unintentional consequences that that definitely we do not want. Then the other amendment is to the actual circumvention device. And the first proposal was to add service, because it's not just a device, it can also be a service. So that is the actual act of circumventing this technological protection measure. But the public also added that you can't just have this first paragraph, this primarily designed to facilitate circumvention. You also need these others. And they read, it will also be a device or a service that promoted, advertised, or is marketed for the purpose of circumvention of a technological protection measure, or with a limited commercially significant purpose or use other than to circumvent a technological protection measure. So if a circumvention device or service, what C says is that you can use it for something else, but it's really limited commercial significant purpose, then it would still be a circumvention device. So the fact that it might be used for something else, but mainly it is for circumvention, it will still be that. So it's simply to tighten up and make sure that we cover what is a circumvention device or service, so we don't leave something out here. And this I would definitely also recommend that we publish it, because this is not something that the public would have seen and be able to have commented on. Now, section 28.0 is the one that deals with technological protection measures and the defense specifically. And another thing that we are adding on technological protection measures that was a concern was raised on is that first off, the definitions were too narrow, but secondly, there was actually no protection in the offences section. Now, when we looked at the offences section, we got a bit concerned about this phrase, has reason to believe. Now, if you make it an offense where you say someone had reason to believe, how do we prove that? And it becomes unfair for both parties, for the state as well as for the person who is accused. Because once the state has proven something, the accused will have to prove his defense. But it might also be difficult for the state to prove that there was reason to believe. So we're proposing that we make this rather a more well-known legal term. A person knows or should reasonably have known. And the should reasonably have known is a test that the courts use. They say whether the reasonable man, I don't know if we can find something like that anymore, reasonable man. But the concept is you look at what would not an expert. You don't expect someone to be an expert, but just a normal person. Would a normal person, from looking at all the factors, have known? And if the answer is yes, then this will be answered in the positive. This person should reasonably have known. A normal person would have known looking at all the circumstances. And so it gives us an objective test, which is a much more fair test when you actually make something an offense. So that is what this change is about here. We do not have to advertise this. It is simply making something more clear, providing for a more objective test. This amendment here, device or service, is simply because we have changed the definition up here to add service. So now we need to just add that throughout the bill. So you will see in the other amendments that I've made, we have the same issues here. As reason to believe, we make it more objective, should reasonably have known. Then the last one here, 6, is a technical amendment. And I've simply added it here because I'm dealing with 28.0. And because, as I've explained before, the Cybercrimes Act is actually repealing these sections. It's not operational yet, so technically this could still be in our bill, but we know that once it becomes operational, it is going to be repealed. And the Cybercrimes Act will actually cover all of these matters. So the proposal is for that just to be removed. The same in 28P in respect of the Electronic Communications and Transactions Act, just remove that. It's a technical amendment. We do not have to amend that, advertise that. Device or service is consequential based on our new definition. And then here we have something else that is new. We do not have to advertise this because normally this act includes the regulations in legislative interpretation. But when we looked again at your offences, we wanted to make it very clear because we are providing that the minister may prescribe acts that will constitute permitted circumvention of technological protection measures. And we wanted to make it very clear that that is what we're referring to. This act, but specifically also something that might be prescribed under this act. And so that is the proposal for that to be in there. And it relates to the offences that I will speak to a little bit later. 28S has exactly the same thing. It is about the reason to believe, to make it just something that is more objectively provable or disprovable, to make the offence itself more reasonable. At this point, I'm not going to go into the offences. The next topic is digital rights. And the offences speak to both technological protection measures and digital rights. So I will deal with it with the offences after I've dealt with digital rights. So maybe just because it was quite a mouthful that I've said, but the main thing here for the committee to consider is the definitions. So the deletion of paragraph B in technological protection measure and the addition of these two paragraphs, in other words, to make sure that the definitions are better worded and provides for a tighter application of the act. And then the rest of the definitions were simply to accommodate the new definitions and also to provide for the offences that are to come. So I will first just pause there.
Honourable members, any comments? So I think, advocates, there will be pressure even on yourself, it looks like, because if ever there's an issue that gets cited and it doesn't get expressed, you might find that those small wordings would actually be something that might be quite helpful. Because if ever you actually cite that you do have it located in this space, meaning 1, 2, or 3, then at least you actually have a fuller picture, so that at least we'll say when nothing is said about it, it can't be interpreted in any way. But if something is said, it's actually a point where the expression confirms that it's understood, it's known, and it has got its own place. Okay, let's check, honourable members. There any further comments?
Chair, there's no hands that I see at the moment, Chair.
Yes, because you see in the engagement that we're having now, advocate, is that you may actually have to, obviously, because it's less of issues that we want to actually debate, discuss on, but the reality in terms of how we should actually be able to understand the issues before us, we will actually find that it moves quicker if ever there's consensus among ourselves to say, if you express it, well and good. If you don't, cite and locate it, and then let's actually see how we actually combine those issues. It does mean then, advocate, that we will proceed, ask you to proceed.
Thank you, Chairperson. So, yeah, I just thought I was on mute for a moment. The next topic deals with digital rights. And the bill already, I think members will recall from the bill dealing with sections 6 and 7 and 8 and so on. This wording here will seem very familiar because we actually just copied from there and made it applicable to digital rights. So the comments were why do you have this applicable to all other works, but not to digital rights, not to published editions and not to computer programs? And when we considered the bill, I actually asked, but why are we not also extending this to broadcasting? And so in case that question does come up with anyone, the reason is that broadcasting rights are still being negotiated. So at this point in time, it would not be good to amend the act in that way, because we don't know what it is going to look like in the end. That is still being negotiated at an international level. But in respect of published editions and computer programs, we can extend already, and that was the proposal. So we will have to advertise this simply because it's new. It's a new clause. And I know the report is currently before the House to ask permission for this to be included. And it really simply adds, so we had to just change the formatting a little bit because the black font is what is currently in the Act. But we're just adding communicating the work to the public by wire or wireless means. And you'll see here wire comes up again. But this is what I talked about, the communicating the work to the public, then covering that wire if we take it away from broadcast. And making it available to the public by wire or wireless means, so that any member of the public may access the work from a place and at a time chosen by that person, and to distribute the original or a copy of the work to the public. Section 11B deals with computer programs, and it is exactly the same wording that is then added. So at this point in time, I will pause there. That is just the digital rights that are extended to published editions and to computer programs. And then the next topic will deal with the offences in relation to both these subjects. But I'll just quickly pause in case there are any questions at this point in time.
Honourable members, Advocate, seeking if ever any further additions. Can I check, Secretariat? Is there any member who would like to get the comment? If not, can we then actually proceed, Advocate, to the next item? Yes.
Thank you, Chairperson. So now we get to offences. And we are going to add it to section 27. Currently in our bill, we have a subsection 5A, but we will have to change that simply so that we deal with it in order. In other words, in the same flow that the bill is, we will deal with the offences as well. So 5A will now become 5B. So let me start first with 5A. This speaks to digital rights. So, and you will again recognize the wording. Any person who at a time when copyright subsists in a work without the authority of the owner of the copyright and for commercial purposes communicates the work to the public by wire or wireless means, you will recognize those words. Make the works available to the public by wire or wireless means so that any member of the public may access the work from a place and a time chosen by that person. Again, you will recognize the words from what we've just inserted into 11A. Which he or she knows to be infringing copyright in the work shall be guilty of an offence. The wording that we used here is the wording that is currently used in the Act. So we aligned it with the Act so that we have that history that we can rely on. And the other thing is that we did not include distribute. So you will remember from here we added 3 rights. So I'm quickly going to scroll back just to the distributing the original is not added as an offence, because it is already contained in communicates the work and makes the work available. That is done by way of distribution. So when it comes to offences, we don't want to create a separate offence for the distribution, because it will be part of these. In respect of section 5B, this deals with technological protection measures, and the concern was that it is not correctly worded to give that protection to technological protection measures. So what we've done first is we've brought in the defense. The defense to circumventing is contained in section 28P. So we've brought that in. So subject to those defenses, if you have then circumvented, if you have made, imported, sold this technological protection circumvention device or service, this is just a consequential amendment. And here's what I've spoken about before, that has reason to believe, which is a subjective test, and change it to an objective test. Device or service is simply the same consequential amendment. And then we've added effective technological before technological protection measure. And the reason for that is when we look at 28.0, it actually speaks to effective technological protection measures, and it explains to us what is an effective technological protection measure. So we can't prohibit something in our act, and we have a lesser requirement in our offense. So we've added the effective there. The other changes throughout this subsection is very much the same as it is currently in the bill. It is really just making it an objective test rather than a subjective test. The consequential amendment because of the definition, and to align it to 28.0 by adding effective. So the last bit that we've changed here is that this offense actually had a fine included in the text, but the bill also proposes a specific fine in a new subsection 6. It says for a first offense, this will be, and for subsequent offenses, that will be the fine. So we propose that this is taken out here so that your offense is aligned with the rest of the act, as was commented on by the public. And then the other addition here relates to copyright management information, because the public commented that this is also not protected because there is no offense for it. And what we have simply done is to actually copy the wording of section 28R, and that has been included here. 28S here provides the defense. When can you, in fact, interfere with copyright management information? So if you have that right given to you in terms of this exception that 28S sets out, then you won't be committing an offense. But for any other thing, any person who, in respect of a copy of a work, remove or modify the copyright management information, or makes or imports or sells or lets for hire, offers or exposes for sale, advertises for sale or hire, or communicates to the public a work or a copy of a work, if the copyright management information in respect of that work or copy of that work has in fact been removed or modified without the authority of the copyright owner, shall be guilty of an offense. So persons who do these two things shall be guilty of an offense. Chair, then I'm just going to pause there because I can already see a hand. Thank you.
Okay.
Ms. Yaku raised the hand, Chair.
Honorable Yako.
Thank you very much, Chair. I'm not sure if I've missed another, because this bill is so technical, but on section 27, on B, the part that says, no, 5A, but B, EB. The part that says, which he or she knows to be infringing. Have we always been gendering those parts in terms of the legal aspect of it, or we do not say they?
Okay.
So I'm saying which they know to be infringing copyright instead of he or she.
Allow advocate, if you can just directly engage on this one.
Thank you, Chairperson. It's actually a very good question, and it's something that in my team we actually discussed very recently. The rest of the Act uses he or she. So at this point in time, it is gender sensitive, but maybe not gender neutral. The only problem is, and I can change it to they. There is one school of thought that says any bill that amends should simply use as gender neutral language, which would be the they. But there's also another school of thought that says we must try and be sensitive to gender, but we need to also follow what the Act says. So what we've done here is to follow the Act. If members say, no, we need to actually be gender neutral, then we can simply change in the bill itself. I can change everything where it says he or she. We can change it to they. We could argue it as a technical amendment and get away with it, even though it's a Section 79 process. We do have some examples of that. So we can do that, but I'm in the hands of the committee. Like I said, the reason was simply to follow the nature of the Act. It is gender neutral, but yes, we can go, sorry, it's gender sensitive, but we can go a step further and actually be it is actually another term for it, and I can't remember it now, but be gender neutral in our drafting. It just depends if the committee instructs us to do that, I can do that.
Yako, you can engage further. Advocate is responded on that one part. Honorable Yako.
Thank you, Chair. I would be more comfortable, I believe, in 2021 as a lawmaker, encompassing all the other bills that have been passed in Parliament, to advocate for a gender neutral term, which is they, because that I don't believe that offends anybody, and I think it's more in line with the work that we've been doing in Parliament in general.
Okay, Mrs. Hermans raised her hand.
Okay, Honorable Hermans.
Chair.
Sure, yes.
Yeah, thank you very much, and thank you to Honorable Yako for bringing that to our attention. Really, in 2021, I agree with her that we should move towards gender neutral writing of legislation. So I think the ANC will support the proposal made by Honorable Yako.
Okay. Advocate, I'm sure in terms of those comments, if there's any other one you'd like to pick up on, and then we can actually just check if there are any further hands. Advocate.
Thank you, Chair. I will do that then. First, I'll make that gender neutral drafting in respect of amendments to be advertised, and then I will work through the bills and just identify and highlight that to the committee. Maybe just in a list, because we don't have to advertise it. It is just something that I'll have to still do, and there will definitely be more than one. So I will do that, and my undertaking will be first just those that need to be advertised, and then I will provide the committee with a list of the remainder. Chair, the next topic is there was a concern raised by the public that we now have this hybrid system. In other words, 12 capital A, sets out a fair use regime. But then we have a list of specific exceptions throughout the bill. And the concern was raised that it is not clear that this fair use concept that we're creating in 12A and the factors that we're setting out in paragraph B of 12 capital A are actually applicable to these other exceptions. So there was a proposal for a new paragraph to say that the exceptions authorized by this Act in these sections, and 12B, 12C, 12D, 19B, 19C, in respect of work or performance of that work, are subject to the principle of fair use determined by the factors contemplated in paragraph B. So these new exceptions are expressly made subject to the fair use factors. Now, you will note that 19D is not included. 19D is our disability clause. And the reason for that is because 19D is we might look upon it as fair use, but it doesn't fall under the fair use exceptions. It is a specific exception provided for by a treaty that has its own factors. So it should not be tested against the fair use factors. So that is why, and because it speaks to the specific treaty, that is why we did not include 19D in this paragraph. Now, although the intention was always for these exceptions to be subject to the fair use principles, I would recommend that this be advertised, simply because it is very new wording to this bill. And you know, it might in the public's view change the concept of the exception under 12B, 12C, 12D, 19B or 19C, and for that reason to give the public the opportunity to comment on this. The Chair, that is this concept. I will first pause there, and we can then just see if there's any comments on that one.
From members, if you can just check, because I think in terms of advocate the point of the new paragraph, the sense was like to make it easier to interpret or to read, because I think in terms of the motivation, that's the sense one is actually getting. Outside that, one doesn't have any specific challenge, but its sense of link to that paragraph in a way that makes it simpler in terms of issues associated with that expression and the amendments of exceptions that should authorize. Are there any further issues?
No hands at the moment, Chair.
Okay, there are no hands, Advocate, if we can proceed.
Thank you, Chairperson. The next one, I have to catch my breath. It's a long one. So what we have here is something called ephemeral rights. It deals with broadcasting. And the wording that we have, I was confused by my own writing there for a moment. This will become paragraph C in section 12, capital B, subsection 1. And the reason for that is because, it was paragraph C. We are proposing, when we look at the duplications, for paragraph B, which deals with education, to be moved to section 12D, which deals with education. So now there's a gap, so it needs to move up. So this will become paragraph B. But if any member is looking at a bill, you will have to look at 12B1, paragraph C. So I'm reading B simply because it is now filling that gap. And of course, all the other paragraphs will move up one. Now, what is happening here? And sorry, I'm going to have to just open my bill quickly because you need to read this in line with the first paragraph, or rather the opening sentence in 12B. And 12B starts with the words, copyright in a work shall not be infringed by any of the following acts. And then we list the acts. So this is the listing of an act. What is the act? The fixation or reproduction by a broadcaster of a performer's performance or work, other than a cinematographic work that is performed live, or a sound recording that is performed at the same time as the performance or work. And then we give some conditions. So in other words, copyright will not be infringed by this act, provided that. Now, maybe just also quickly before I continue into all the provisos, what was proposed is that we look at the Canadian Act and that we use that wording there. Now, in order to fit the wording from the Canadian Act into our bill, we had to change where things were situated. So we listed all the provisos together, and then there is a new subsection 2 that I will get to. So the wording here comes from the Canadian Act's wording. And like I say, they call it ephemeral rights. So one of the provisos is the broadcaster must be authorized to communicate that performance, work, or sound recording to the public by telecommunication, provided that the broadcaster makes, so in other words, every time we need to read that little sentence before we go to a subparagraph, provided the broadcaster makes the fixation or the reproduction itself for its own broadcast. So they can't make it for another, can't release it to someone else. The broadcaster does not synchronize the fixation or reproductions with all or part of another recording or other performance or work. Provided that the broadcaster in 4 does not cause the fixation or reproduction to be used in an advertisement intended to sell or promote, as the case may be, a product, service, cause, or institution. Provided that the broadcaster records the dates of the making and destruction, sorry, I'm going to just go up a bit, down a bit, records the dates of the making and destruction of all fixations and reproductions and any other prescribed information about the fixation or reproduction. And another provided here, provided that this record that the broadcaster is keeping must be kept current, and the broadcaster shall make this record available to the owners of copyright in the works, the sound recording, or performances, or the representatives within 24 hours after receiving such a request. In other words, a request to make it available. So not only will you have to keep the record, you will have to keep it current, and you must make it available within 24 hours. Then provided that the broadcaster destroys the fixation or reproduction within 30 days after making it, unless it is deposited in an archive, and the archive comes in paragraph 7, and we'll deal with that now. Is deposited in an archive in accordance with subparagraph 7. The 7 we refer to here, and I'll deal with it now. or where the copyright owner authorizes the retention thereof, which authorization may be subject to the payment of applicable royalties. So it must be destroyed within 30 days, unless it goes into an archive and there's prescripts for when it can be archived, or the copyright author authorizes that retention, but may charge a royalty for that retention. And then provided that the broadcast is authorized to, with the consent of an official archive, to deposit the fixation or reproduction in that official archive, where the broadcaster considers that fixation or reproduction to be of an exceptional documentary character, and provided that the broadcaster shall, within 30 days of such deposit, notify the copyright owner thereof. So he can't do it in secret. He has to tell the copyright owner, I regarded this as exceptional documentary character, and with the consent of an official archive, I deposited the fixation into this official archive. So these are all the requirements and the rights that are attached to this broadcaster's actions. Then we have a new subsection, and we simply indicate that this paragraph, subsection 1, paragraph B, so this whole paragraph that I read now, does not apply if a license is available from a collective society to make the fixation or reproduction of the performance work or sound recording. In other words, if there's a license available, you must revert to that. You can't then make use of all these, or rather of the rights in B, which are then subject to all these rights listed in the paragraph. So it's a bit of a mouthful. It's not an easy concept. I even still struggle with it. But this deals with fixation or reproduction by a broadcaster. So this now, where it was a very tiny paragraph, it is now quite broad. It sets out what must be done, how it must be done, how long, etc., etc. So Chair, I'm going to just pause there and see if there are any questions on this one, the ephemeral rights.
Okay, honorable members, if ever we can actually get your comments.
No hands at the moment, Chair.
Okay, because I think largely one gets the sense that there was an enlargement part to make sure that the legislation is accommodating. Because if ever it's not, you might find that there's lots of explanation when things have gone wrong already. But this one is more to guide to a large extent. Are there any comments, members, or can we actually then go back to the advocate to proceed? It is a lengthy input, advocate, but it does actually make sense to accommodate the issues which might be relevant in the space of issues we're focusing at. Advocate?
Thank you, Chairperson. The next is the wording of the three-step test being added to sections 12C and to section 12D. Now, first on section 12C there was a technical amendment required because this phrase here was actually part of B there, and it shouldn't be. And so we just moved it back so that it applies to both A and to B. And then also it was talking about economic significance, and we changed it to commercial. Commercial is actually defined in the bill. So it does make sense to make that change. This does not have to be advertised, but now we get to the three-step test being added, and that will have to be advertised. Oh, sorry, I did not say, but on the ephemeral rights, that whole insertion will have to be advertised as well because it's all new, and people would definitely not have seen it. So back to three-step test. So what we're referring to here, we're talking about transient or incidental copies or adaptations of a work. So we are saying transient or incidental copies or adaptations of a work contemplated in subsection 1. So we've made the link. May, now these are the three steps. Only in specific cases. May only be made in the cases stipulated in subsection 1. May not conflict with normal exploitation. May not conflict B with the normal exploitation of the copyright work. And may not unreasonably prejudice legitimate interests of the copyright owner. C, may not unreasonably prejudice the legitimate interest of the copyright owner flowing from their copyright in that work. The reason for adding this last bit over and above the three-step test wording is that there were some comments that indicated that you need to be cautious when you talk about the rights of the copyright owner, because or what the copyright owner might approve, because a copyright owner might want to say, well, I do have a different right, I do have a different interest, and that interest might not necessarily be related to copyright. It might be on something else. I might have an interest here to make more profit. I might have an interest here to whatever. There might be something different from copyright. So, and because treaty wording is done on an international level, it's based on negotiations, wording changes, countries bring their type of legislation into the way they word their legislation into the treaty language. And parties in the end up with a compromise, and that is where the wording comes from. So it is accepted that the wording of a treaty will not necessarily be something that you can just take and transplant into your law. You might have to convert it a bit to fit in with your legal concepts, with your legal wording, with the way that you draft. So we brought this in to make it very clear that this unreasonable prejudicing that we're talking about, and the interests that we're talking about are those flowing from copyright. This is the Copyright Act that this bill speaks to, doesn't go broader to other rights that you, or other interests that you might have under something else. If it's in terms of another act, that act must allow for your interest. Here we only align for interests flowing from copyright. So that is the first where we put the three-step test in respect of 12C. Then 12D, the same. But also here it's just a consequential amendment. You will recall that I talked earlier as well about we deleting certain sections from 12A to avoid duplication. And this, if we don't add this, it will actually go amiss. And the reproduction that we're talking about here, it includes a lawful copy that you make at a different time or a different device owned by that person. So we're just adding it here so we don't lose it from 12A. And the provisions that we have here, first off, is the fair practice that was currently part of the bill, but we have changed, it was to the extent justified by the purpose. And the comment was, don't use that phrase, rather use fair practice. It's more aligned to treaty language. So that is what that change is about. And then the three-step test comes in B, C, and D. And you will see that it's very similar to 12C. A reproduction, because that's what we're talking about here, reproduction of a work, may only be made in cases stipulated in this section, so in section 12D. The reproduction does not conflict with the normal exploitation of the copyright work, and the reproduction does not unreasonably prejudice the legitimate interests of the copyright owner flowing from their copyright in that work. So the same arguments that I've given before are again applicable here. Then these following ones, we don't have to advertise, but because it's part of this section, I just thought to raise it here. This first one deals with the moral rights. So I've spoken to it about it before. The bill talked about insofar as it is practicable, and people were saying it differs from person to person what is practicable, and we should rather use the wording of the act, which is if it appears on the work. So that is what we have done there. Again, fair practice, to say the use of the work shall be compatible with fair practice, instead of must not exceed the extent justified by the purpose. So just change that to accommodate the treaty language, and the same in 9 in respect of the treaty language. 9, however, is new to 12D. So 9 comes from section 12B. And that is where I said we are going to move in subsection 1, paragraph B will be moved here because it deals with teaching. So just to put all the teaching provisions into one. So it's just moved here, and then it's just minor things to change the wording. This or in the work is part of the bill, but when we look at all the wording that is used in the rest of the act, it simply talks about if it appears on the work. I think on the work captures it sufficiently. It's not necessary to say in the work. Okay, so I'll first pause there. the big thing here is the wording of the 3-step test, which will definitely have to be advertised so that we can get that input. Before I pause, apologies. There's one additional thing that I just want to add. And we'll probably also we will see something from this when it comes from public submissions. There is a school of thought that says if you look at your 3-step test, it is not meant to be something that is limiting. It should be something that is enabling. If you include the wording of the 3-step test in your legislation, it becomes limiting. It doesn't mean it's wrong. It just means you need to be aware that it becomes limiting instead of being the enabling tool that it was envisaged to be. And in respect of 12D specifically, because this deals with education, we need to just keep in mind it might be challenged here in 12D in respect of education. But it is something that will have to be published, and my recommendation would be that we publish the wording and we get the comments from the public, and the committee can then consider it. At the time when we consider the submission from the public, I will raise that again and just highlight to the committee so the committee is aware of the environment that they are deliberating in. So Chair, I will just pause there for now because that is it on including the 3-step test.
Chair, there's no hands at the moment, Chair. The chairperson.
Sorry for that, I was muting.
No hands at the moment, Chair.
No hands at the moment, yeah. Okay, then let's actually then go back to the advocate, because advocate, it does look like the words that are added to make things simpler and to a point where we are able to actually accommodate issues that may actually come up because of those who are not actually used or not actually familiar with that kind of engagement. Are there any further comments? If not, can I ask that advocate proceed?
Thank you, Chairperson. The next one, when I first spoke to this proposed amendment to the committee, I indicated that there would not be any need for an advertisement because we are simply removing a duplication. And what we have in section 19C is that in subsection 1, we say that the bill indicates that you may not be doing any of these works contained in 19C or these acts contained in 19 capital C for commercial purposes. So it's not necessary to repeat it in subsection 4. But when we discussed the wording, the proposal was that we only remove the words for commercial purpose. Now that changes subsection 4 then, because if we leave this sentence by itself, may not permit a user to make a copy of a recording of the work, it actually expressly prohibits the making of a copy or a recording of the work, which might be acceptable. I'm not saying it's not acceptable, but it just changes what we are saying. Because if we say you may not permit the copy or recording for commercial purposes, it is implied that you may allow it for non-commercial purposes. So because of that change in meaning, I would recommend that this amendment be advertised so that when the public looks at this, because they might have thought to themselves, yes, I agree that there should be copies for non-commercial purposes, but now we are removing that. And because of that removal, I will recommend that this be advertised. Chair, that is all on this subject. It's quite a short one. So I'll just pause there for now.
Honorable members, if ever there are any comments.
There's no hands, Chair.
Okay, so I think we can actually then be able to proceed, Advocate.
Thank you, Chairperson. Chair, those were all the amendments that had some aspect of advertising involved in them. The remainder of the amendments that I'm going to go through don't have to be advertised. And the first one I'm actually going to present with the second one because the committee has already agreed on these. So when the committee initially discussed the reservations of the president, there were these retrospective clauses that the president was concerned about, as well as delegations to the minister that related to the retrospective clauses. So these are just the amendments that will be made in that regard. So I'm not going to go through them too much because they've already been agreed on, and actually they just need to now be populated into a C list. The next one that I'll speak to is about removing duplication. So I've already mentioned a few where we're removing duplication. Changing wording to be more similar to the treaty, and this is the issue of fair practice versus to the extent justified by the purpose. And the last one is in respect of changing wording for the moral rights of the author. So instead of saying where it is practicable, you should be mentioning it. We are saying you should mention it if it appears on the work. So it is all in blue, so I'll probably be able to go quite fast through this. But let me just first focus on these where I'm omitting things. And all that is happening here is we are removing duplications. And the specific duplications in one deals with research, private study, or personal use. So research and private study, you'll know we're dealing with in 12D. Personal use, we've had that whole presentation on personal copies. That is covered in 12B, subsection 1, paragraph I. Subparagraph 4 that will be deleted deals with scholarship, teaching, and education, again, 12D. And paragraph 6 deals with libraries, archives, and museums, which we know is also covered, I think, in 19C. So that is just why those are removed, because they're already covered in specific exceptions that are actually featured in a section of their own. Then 12C is just the moral rights, so as well as the name of the author if it appears on the work. 12B1, paragraph A, subparagraph 1 is to change to the extent justified by the purpose, to change that you're compatible with fair practice. The same in paragraph 2, subparagraph 2, to just change to the extent that it is practicable, and then also that or in the work, because the rest of the act speaks of on the work, and then we've also used that in our bill. This is the paragraph B that I'm talking about here, is that one that I've just worked through with the committee before that is now under education. 12B1 paragraph D is just to correct the the wording in respect of moral rights of the author if it appears on the work rather than practicable. Same as in E, if it appears on the work, means that referring to the name of the author must be indicated. Then on page 13, from line 13 to subparagraph 1, the paragraph that we are referring to here deals in fact with reproduction by the press of things for, so I'm trying quickly to read, the reproduction by the press or in a broadcast transmission or other communication to the public of an article published in a newspaper or periodical on current economic, political, or religious topics. And the reason that is removed from 12B is because it is fully covered in 12 capital A. Then changing in 12B subsection 1, paragraph E, subparagraph 2 and 3, just the issue of fair practice instead of to the extent justified by the purpose. In subparagraph 3, I just had to switch the wording around. So I'm starting for purposes of providing current information, because when I added the wording shall be compatible with fair practice, the sentence became a bit lopsided. So I had to just move it around so that it reads a bit better. In respect of translations, we discussed the addition of the two purposes in respect of language and culture, which came from the public, and the fact that it's of course done for non-commercial purposes. So it's just made very clear, and provided that it's compatible with fair practice instead of to the extent justified by the purpose thereof. So Chair, that is the I think let me pause there. There's quite a lot, but like I said, it's not advertisement. It's really just changing wording and removing duplication, and just aligning the wording of the bill throughout so that it is aligned in the bill itself, but also with the act. So I'll just pause there for a moment.
There's no hands at the moment, Chair.
Oh, okay, okay. No, Secretary, I think in terms of the clarity of the advocate, it does look like we can proceed. Let's check members. Any comments? Any clarity seeking question? Well, in the absence, I think Secretariat, we can proceed. Advocate?
Thank you, Chairperson. I think that the next few I'll just do as one, because these deal with amendments to the Performance Protection Amendment Bill. The first amendment is just to accord with treaty wording. The argument that was made by the public was that we can't have royalties or equitable remuneration in the same sentence with both audiovisual works and sound recordings, because it causes confusion. So it is just made clear now that royalties or equitable remuneration relates to audiovisual works, whereas equitable remuneration relates to sound recordings. So it's just to make something clear and to align it with the treaty wording. Then just technical amendments, apologies, there is one copyright, relating to a cross-reference that was incorrect. The second one is in respect of inserting the word into in the sentence because it was missing. And then just two technical amendments flowing from the amendments that I've already discussed under 28O and P, because we are also repeating the wording of these two sections in the Performance Protection Amendment Bill, just to remove the reference to the Electronic Communications Act. And Chair, those are all the amendments. So I will pause there if there are any questions on the technical amendments themselves or on the treaty wording to align it and make it clear. Those are the last of the proposed amendments. Thank you, Chair.
Well, members, on the treaty or amendment, if I can take your comments with the input of the advocate. Honorable members?
No
if there are
hands.
none, yes, Secretariat?
No hands, Chair.
Okay. Yeah, I'm sure we can proceed, Advocate.
Thank you, Chair. That is me for presenting the wording of the proposed amendments. Chair, I think also maybe Mr. Hermans can also assist. I think that what the committee needs to decide now is whether they are ready to confirm that this is the wording that has to be advertised. Whether this should first, members first want to consider the wording and then come back. But that is for Mr. Hermans to guide the committee on. So I'll hand back to him, Chair. Or
Okay.
to you, and then suggest that he advises the committee.
Okay, I'm sure that's in order. Then we can actually go back. I think it's process linked to what the committee way forward should be. Secretariat?
Chairperson, based on what Advocate van der Merwe presented to the committee this morning, I think it's quite a mouthful. We are possibly, and we will be guided by the committee, is that the committee may want to have amongst themselves in the respective caucuses, want to have a discussion on what has been presented by Advocate van der Merwe, and may come back next Tuesday just to confirm, or if there's any proposals that they want like the committee to consider and make and submit those proposals, or the committee can today say they are okay with what has been presented and what has been proposed to be advertised and going forward. So we basically in the hands of committee. The one option is for the committee to take, for members to take this to the caucuses, have further discussions on the matter and come back next Wednesday, or maybe of the view that they're fine with what has been presented and we are clear that these are the matters that require to advertise, Chair. Thanks.
Yeah, I think you quite correct then, Secretariat, that the committee members will be able to go back and do further consultation, go through the processes as well in trying to check if ever there are areas which may need to be added from parties. And then we actually can be able to have a look at that. So structure in terms of implementation secretariat, one was actually saying that with the options, it does actually mean that the time we have and the scheduled program, it will be actually in order that we are able to reconvene next Wednesday, further engage on the issues that have come up, and be able to actually get to the committee to take resolutions and have sufficient space for consultation as well.
Next Tuesday, Chair, not next Wednesday. We'll come back next Tuesday.
Oh, it's not Wednesday. Okay.
Tuesday.
All right. So let's actually then get members with that comment from the Secretariat.
Chair, Mr. Benson Amashe, how do you raise his hand? And Mrs. Hermans, Chair.
Honorable Benson Amashe.
No, thank you very much, Chair. I think Honorable Whip will deal with the process issues, certainly as they would talk to party caucuses. Mine would be to look at the bill as being tagged as a Section 76 bill, just to confirm something from advocate that, look, after all is said and done, this bill will be referred to the NCOP, and the NCOP, what I want to check, the NCOP, will it deal with it to the extent that will limit its engagement to the reservations as raised by the president? Or will the NCOP deal with the bill as if it is a new bill presented before them? Thank you very much.
Okay, Honorable Hermans.
Thank you very much, Chair. I've seemed to have lost my ability to raise my hand, but while I have the floor, I just want to endorse what the proposal that was made by the PC Secretary and yourself, that we take this back to our caucuses and just make absolutely sure that this is what we want to do and propose in the PC. Thank you so much.
Okay, so there is, Secretariat, the suggestion which members seem to accept. Can I just confirm if there are no portfolio committee members who have a different suggestion or view? Then we can actually proceed on the basis of the further consultation. And then as scheduled in our own program, implementation in proceeding further after consultation. Can I then take that as consensus? And then
yes, Chair.
Yes, Chair, thank you.
Okay, can we then actually then proceed and go back to the committee secretariat? Because in terms of our program for today, it's actually the work done, given back to the committee to consult and come back and continue to process. So let's actually round up. Yes, yes.
There's just a matter that that Mr. Benson Amashe has raised for a response, Chair. I don't know if Mrs. Emmons wants to raise that.
Yes,
okay,
no, I was just, yes, Chair, I was just, it's an important question and I just wanted the advocate to speak on it. Thank you.
Okay.
Thank you,
Amashe raised that point. Let me just check if the advocate did pick on that.
Yes, Chair. I'm ready to respond to it.
Thank you.
Thank you,
Proceed.
Chair. Yes, it's a very important question because it also affects. It doesn't affect the process in this committee, but there might be some strategic things that could be dealt with in the NCOP because it can't be dealt with in this committee because of the Section 79 restrictions. Because the Section 76 tagging indicates process. So what tagging does is it indicates what the process is that a bill will follow in the National Assembly and what it will follow in the National Council of Provinces. And if there is a disagreement about the bill, what the mediation or no mediation process will be. So Section 75, if there's a disagreement, there will not be a mediation. The National Assembly will take the final decision. And also the process in the NCOP is very different. It is not something where there's mandates involved from the provinces, etc. So because these bills have been changed now in their classification to Section 76, the process in the National Council of Provinces in respect of both bills will have to start over because it's very different from Section 75. So the whole bill will be open before the National Council of Provinces, in respect of both bills, both copyright and the Performance Protection Amendment Bill will be open in full before the National Council of Provinces. They will have to be briefed on both bills as if they've never seen it before. Then it will go to provinces. Provinces will have to be briefed as if they've never seen it before. There will be a process of negotiating mandates from provinces. Of course, there will also be public participation. And I believe at the point in time, the select committees also do public participation as a committee. There will also be public participation in the provinces. Those will be deliberated on. There will be negotiating mandates that will come to the committee, and it will follow a normal Section 76 process as if the bills are before the NCOP for the first time. Thank you, Chair.
Oh, I'm sure it does actually clarify, unless there's follow-up question. If not, I think then we can pick up the Secretariat on the way forward, linked to the earlier discussion. Secretariat?
Chair, Mr. Burns Ngamashi raised his hand, Chair. I do not know.
Okay. Honorable Ngamashi.
No, thank you very much, Chair. I'm happy with the explanation clarified by Advocate van der Merwe, because it then begins to say to all of us that any other matter that may have been a concern will still have an opportunity to be addressed and or ventilated at the level of the NCOP processes, particularly as the NCOP will, among other things, conduct its public hearings at provinces, where the most people who are actually affected by the implications of this envisaged legislation reside. So from where I am sitting, Chair, it opens up a window of opportunity for whatever that needs to have been looked at to be thoroughly engaged. So I'm quite happy with that. Thank you very much.
Okay, Secretariat. I'm sure based on the earlier point, we can pick up Secretariat.
Chair, based on the decision of the committee will return on Tuesday. Hopefully, parties will have a clear position on the matter, and if there's any changes that need to be addressed, the parties will raise it in that particular meeting, and then they will move forward on to continue with deliberation. So next Tuesday, parties will be given opportunity to express themselves on what has been presented, Chair. And if any changes are being proposed, committee can consider it. and thereafter the committee then will proceed with preparing the bill on matters that needs to be advertised. And then we'll continue the next day on Wednesday with deliberations on other matters that may not require to be advertised and try to get a resolution on that, Chair. Thanks.
And then Secretariat, if it's actually next Tuesday, obviously that will speak to our next meeting in terms of our program.
That's correct, Chair. What probably we'll propose also the document that was before the committee, we will maybe just make it clearer clear in the document what needs to be advertised so that members is clear on that going forward. So we maybe send a cleaner version, a redraft, not a redraft, but just a version that clearly indicates that clause X and clause Y must be considered to be advertised, Chair. Thanks.
Okay. In terms of our own agenda, I'm sure the item is what we're looking at, unless there are issues which you'd like to talk to Secretariat.
Chair, there's no further issues. That was the business of the day. If the committee seems to have concluded, so the meeting is, you can adjourn the meeting if you so choose, Chair. Thanks.
Okay. Thank you very much to honorable members, advocate, and the Secretariat. Allow me to actually adjourn our meeting. And I'm sure in terms of our program, we will actually then be able to reconvene by next Tuesday. Thank you very much. Our meeting is adjourned. Thank you.
Thank you, Chair.
Thank you, Chair.
Thank you, Chair.
Thank you. Thank you.
Thank you, Chair. Enjoy your day.